Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the termination of a guardianship upon the death of a disabled adult in Illinois. Let's first talk about the responsibilities of a guardian after a ward dies. So a guardian is the person responsible for making financial and or personal decisions on behalf of a disabled adult that, due to a physical or mental disability, lacks the ability to make those decisions on his or her own. The guardianship technically terminates when the disabled adult passes away. However, the guardian still has a couple of responsibilities after the death of the disabled adult. The first is the duty to file a final report with the guardianship court. So a final report will lay out the state of the disabled adult's estate after the guardianship ends, and it'll set forth all of the assets, liabilities, income, and disbursements from the estate, and everything that's basically happened financially while the guardian has been in charge of the disabled adult's financial estate. The second responsibility is to protect the assets of the estate and continue to manage them prudently until the assets are transferred to the custody of the executor or administrator of the deceased disabled adult's estate in probate. So let's go into that a little bit. And let's talk about who's responsible for managing the estate of a deceased disabled adult. The guardian remains responsible for the estate of the disabled adult until letters of office are issued to an executor or administrator of the estate by a probate court. And let's unpack that. So probate is a court case that is sometimes necessary in Illinois to give an executor or administrator the power to collect the assets of a deceased person and then distribute them first to creditors, the people that the deceased person owed money to, and then the remainder to beneficiaries under a will or heirs according to state statute if there is no will. The executor is the person named in the will that's responsible for managing the estate. An administrator is someone who manages the estate if there is no will or if there's nobody named in the will that's willing or able to act as an executor, and the administrator is appointed by the court. So probate isn't always necessary. It's generally necessary if you own any real estate or more than $100,000 in non-real estate assets in your individual name outside of a trust. So if probate is necessary, the first thing that will happen is a potential executor or administrator will file a petition to open the probate estate, have a will admitted to probate, and then there will be a court date at which the court will issue letters of office if no one objects to the person seeking to be the executor or administrator of the estate. Letters of office are the court order that gives the executor or administrator the authority to manage the estate and make financial transactions in order to transfer assets into the estate from the deceased individual name and then disperse them to creditors and heirs. So at that first court date of a probate case, the first thing that will happen if everything's going well is that letters of office will be issued to the person who is seeking to be named executor or administrator. At that point, once those letters of office are issued, that's when the guardian can transfer custody of the assets from his or her custody, the guardian's custody, to custody of the probate estate by way of the executor or administrator. And that's when the guardian's actual responsibility for those assets ends, is once the custody of the assets is transferred to the person responsible for actually managing the probate estate. Now, the executor or administrator might be the same person as the guardian. So in that case, the responsibility will shift from a guardianship responsibility to a probate responsibility. So we've talked about what happens if probate is necessary. If probate is not necessary because the disabled adult didn't own any real estate outside of a trust, had less than $100,000 outside of a trust or outside of payable on death accounts, and there are no disputes about who's going to get paid in the estate, if probate is not necessary, then the guardian can go about dispersing the assets of the estate through a small estate affidavit. And this is just basically a document whereby the guardian swears under oath that probate isn't necessary based on those things we just talked about, and states who is going to inherit the assets and how those assets are going to be divided. And with that small estate affidavit, the guardian will have the power to distribute the estate to beneficiaries under a will or any heirs according to state statute if there is no will. So the guardian will retain responsibility for the assets until they're transferred to the estate if there's a probate case. And that can happen after letters of office are issued, basically the badge giving the authority to the executor or administrator. Or if there is no probate case that's required, then the guardian himself or herself can go about distributing the estate outside of probate through a small estate affidavit. So if you have any questions, you can ask them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, including guardianship and probate. And we have offices in many geographical locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com. Call us at 630-324-6666 for a free consultation.